Good afternoon. My name is Mike Alford and I'm Chief Risk Officer for Habitat for Humanity of Hillsborough County. On behalf of Habitat, I would like to congratulate you on your decision to partner with the organization in beginning your journey towards home ownership. Your dedication and hard work will soon be rewarded on the day of your home dedication when you take those keys and step into your forever home for the very first time. We're proud to be partnering with you in that journey. Part of this journey, as you may know, is thinking about and planning for your acceptance and your ownership of probably the largest asset that most of us will ever have in our lifetime. And coming along with that, there are certain legal concerns regarding the titling of your property, thinking about the estate planning that might go along with that. What you're doing with this process in part is creating intergenerational wealth. That's something very important, and it's an incredible opportunity not only for you, but for your children and the heirs that come after you. In that vein, we will be talking today about Florida wills, the probate process, and the importance of titling your home as the most valuable asset that you may have. Now, I need to give you a disclaimer before we begin. Although I'm an attorney with Habitat, I am not giving you legal advice. I'm not permitted to give legal advice by the Florida Rules of Ethics. We will be generally describing legal concepts, but if you need legal advice concerning any of the topics that we talk about, I encourage you to seek out your own counsel. This can be done by consulting with a private attorney. It can also be accomplished by working with various organizations such as Bay Area Legal Services. I encourage you to consult with the good folks here at Habitat if you have questions about that, and you can go online, for example, with Bay Area Legal Services, www.bals.org. Today, as you'll see from our outline, we will be covering several important topics. First, we will discuss titling the assets, how assets such as a home may be titled appropriately under Florida law. We will be talking about the probate process and why that's important to you as you plan for the purchase of your home. We'll talk about the importance of executing a will and how that can help you in terms of estate planning and thinking about the future for yourself and your family. We'll also be discussing the meaning of the Florida homestead rules and the exemptions that apply, and we will review other estate planning documents. Let's begin first with titling of assets. Now, the importance of a title may be self-explanatory, but it certainly impacts your authority to sell, transfer, gift, or mortgage your property. It's significant for all assets, including real estate, but at this point, of course, in this class, we will be focusing primarily on your home. And it also impacts the probate process at such time as a homeowner passes. In titling assets, we will also be considering major life cycle events that can impact the title and the method of transfer of assets, including real estate. These would include marriage, births, divorce, or death. All of those can impact the ownership of the home and should be considered in planning. And we'll also talk about the types of ownership. Generally, the most common are single owner title in single name and joint ownership of homes. Beginning with individual ownership, for a single individual, this would allow an owner to sell or otherwise deal with the property during his or her lifetime, and at death, the owner would be able to dispose of the property through a will or a trust subject to homestead restrictions. The next type of ownership that we will cover are tenants in common. In a tenants in common situation, there are multiple owners, first of all. Each owner, referred to as a tenant in common, owns separate and distinct shares of the same property. By default, all co-owners own equal shares, but their interests may differ in size. In the absence of any restriction agreed to between the tenants in common, an owner may sell or otherwise deal with his or her interest in the property including the mortgage, during his or her lifetime. There is no right of survivorship, and at the death of the owner, his or her interest passes by will, trust, or through the operation of the laws of the state of Florida in the event that the owner dies intestate without a will. Next type of ownership that we'll be talking about today would be joint tenants with right of survivorship. This is a common form of ownership between a husband and a wife, whether it be a home or a bank account or other property. In the joint tenants with right of survivorship situation, the co-owners have a right of survivorship, meaning that if one owner dies, that owner's interest in the property passes to the surviving owner or owners by operation of law. The owners generally share an equal interest in the property in the context of joint tenants with right of survivorship. If any joint co-owner deals in any way with a property inconsistent with a joint tenancy, that co-owner will be treated as having terminated the joint tenancy, also called breaking the tenancy. And then lastly, we have tenants by the entirety. Tenants by the entirety is a special form of ownership that is only available to married couples. A married couple takes the whole estate as a single person in the eyes of the law, with the right of survivorship as an incident, so that if one dies, the entire estate belongs to the other by virtue of the original title. The property owned by spouses is held in tenancy by the entireties, absent some express indication to the contrary. So that is the default form of ownership unless it's otherwise specified in the title. The final form of title that we'll be talking about today is payable on death accounts, also called POD accounts. Let's talk about the differences of designating a payable on death beneficiary. This can be done with bank accounts, retirement accounts, insurance policies, annuity contracts, and securities. And the way that it is accomplished is designating payable on death, transferable on death beneficiaries. POD forms can be provided by banks, brokers, or insurance companies. The primary advantage of a payable on death account or a POD account is that it avoids probate without granting the payable on death beneficiary access to your account during your lifetime. And so that brings us to the probate process. What is it? Probate process, the probate is a court-supervised process for identifying and gathering assets of a deceased person, also known as the decedent, paying that person's debts that were accumulated during his or her lifetime, and distributing the assets to his or her beneficiaries once the process is completed. There are two types of probate generally. The first is a formal administration, which is handled by the court through formal process. The second type is summary administration, which can be used in a case where the assets of the decedent are less than or equal to $75,000. All debts have been paid and or creditors don't object to the process being used. In general, the decedent's assets are used first to pay the cost of the probate proceeding. Then they're used to pay any outstanding debts which remain after the person's death, and then the remainder is distributed to the decedent's beneficiaries. Why is probate necessary? Well, the process passes ownership of the decedent's probate assets to his or her beneficiaries. If there's a will which directs the distribution of assets per the person's wishes that were expressed during the lifetime, that will also be admitted to probate. And to the extent legally possible, the court will follow the wishes of that person. And we'll talk in a minute about why that's advantageous to have a will in place. It also winds up the decedent's financial affairs and ensures that the person's creditors are paid where procedures are followed correctly. Finally, property transfers title to homestead and all of the decedent's other assets. What are probate assets? Probate administration, first of all, probate administration only applies to probate assets. Probate assets are those assets that were owned in the decedent's sole name at death or owned by the decedent and one or more co-owners and lacked a provision for automatic succession of ownership at death. Probate assets can include, for example, a bank account in the sole name of a decedent. However, a bank account owned by the decedent and payable on death or transferable on death to another or held jointly with rights of survivorship with another would not be a probate asset. A life insurance policy, an annuity contract, or individual retirement account that is payable to a specific beneficiary would not be a probate asset. Real estate titled in the sole name of the decedent or in the name of the decedent and another person as tenants in common is a probate asset unless it is homestead property. But real estate titled in the name of the decedent and one or more other persons as joint tenants with right of survivorship would not be a probate asset. The reason for that would be that upon death, the ownership of the asset automatically transfers to the joint owner in a right of survivorship situation. Property owned by husband and wife as tenants by the entirety is also not a probate asset on the death of the first spouse to die, but would go automatically to the surviving spouse. The probate process requires that the court appoint a personal representative for purposes of the state of Florida where we are. A personal representative can be an individual, a bank, or a trust company subject to certain restrictions. To qualify to serve as a personal representative, an individual must either be a Florida resident or, regardless of residence, a spouse, sibling, parent, child, or other close relative of the decedent. A personal representative that's named in a will is generally appointed as long as the named person, bank, or trust company is legally qualified to serve. If the decedent did not leave a will, then the surviving spouse has the first right to be appointed as the personal representative. If there is no surviving spouse, the majority in interest of the decedent's heirs appoint the personal representative. Now let's talk a little bit about what the estate's obligation to estate creditors would be. Primary purpose of probate, as we just covered, is to process claims of creditors and satisfy outstanding debts of the individual who is deceased. The personal representative is required to give notice to all known or reasonably ascertainable creditors. Creditors who receive notice of the probate administration generally have 3 months to file a claim. The legitimate debts of the decedent specifically include proper claims, taxes, and expenses of the administration of the decedent's probate estate, and they must be paid before distributions are made to the decedent's beneficiaries. Assets subject to debts distributed by the estate remain subject to debt in the hands of the beneficiary. A good example of that is if you inherit a home with a mortgage balance, you will of course be obligated to continue to pay the mortgage. You don't inherit the home free and clear if there's a mortgage on that property. Yes?
Could you sell the house and pay off the debt?
Okay, great question. Yes, if you wanted to liquidate the asset, you would first, of course, have to satisfy whatever mortgage balance remained, and all other things being equal, just receive the value from the sale of the property. Absolutely. How long does the probate process generally take? Well, it really depends on the facts of each situation. The personal representative may need to sell real estate before settling a probate estate. There may be disputed claims from creditors that could take time to work their way through litigation. And there could be challenges to the validity of a will, depending on what the situation is. Now, in general, the probate estate must be open for at least a 3-month time period for creditors to make claims on the estate. It's reasonable to expect that a simple probate would take 5 to 6 months to be handled and concluded. There is a way to avoid probate, and that's by adding the POD beneficiary or co-owner and the use of revocable trust, which we'll talk about next. Now, we spoke in the beginning about a will, the importance of thinking about putting together a will and why you would consider doing that. So let's spend a few minutes talking about that. First of all, what is a will? A will is a writing signed by the decedent at the time with two witnesses that meets the requirements of Florida law. In a will, the decedent can name the beneficiaries of probate assets. The person can designate a personal representative, which is Florida's term for an executor, to administer the estate. And the individual can also nominate guardians of his or her minor children as part of that document. The significance of a will is that it overrides the default treatment that is created in a situation where a person dies without leaving instructions as to how they wish their estate to be handled. If the decedent's will disposes of all of his or her probate assets and designates a personal representative, the will control over the default provisions of Florida law. If the decedent does not have a valid will, or the will fails in some respect, the identities of the persons who will receive the person's probate assets and who will be selected as the personal representative of the probate estate will be as provided by Florida law. So essentially what this means is that in the absence of a will, you will lose your ability to control the manner of distribution of your assets and who in fact might receive those assets, and it may be something that you did not intend during your lifetime. So it's important to consider putting a will together. And again, at this time, I would encourage you to sit down with an attorney to review. It doesn't have to be an overly complicated process. There are simplified forms that can be used, but I do think it's best if you're able to sit down with qualified legal counsel to review that. The will itself is not complicated. All it requires is that you be of sound mind and body at the time you execute it, and that you have two witnesses who sign in your presence declaring that this is in fact your intentions regarding your estate after your passing. You can also change your will if you decide to, as circumstances change over time. If there are minor changes to your will that don't require a complete rewriting of the document, you can execute what's called a codicil. A codicil can be added to the original document, and it just requires the same formalities, meaning the signature of the person whose will it is, along with two witnesses who are there at the time of the signing. So it's not an overly complicated process, and it really will help you in terms of thinking about how you want your estate to be handled after you're gone. What happens if there is no valid will? A person who dies without a will is considered to have died intestate. That means that the court will appoint a personal representative, and the assets will be distributed according to the Florida statutes on the probate law. Now, let's talk a little bit about what that would be in terms of the distribution priority if you, in fact, died without leaving a will. Generally, the assets are distributed to your heirs in the following order of priority. Number one, if you're survived by a spouse and there are no other living descendants, your surviving spouse receives 100% of your assets. If you're survived by a spouse and you've left one or more living descendants, all of whom are descendants of both you and that spouse, and the surviving spouse has no additional living descendants, the surviving spouse will again receive 100%. The decedent is survived by the spouse and left one or more living descendants, all of whom are the descendants of both the decedent and the spouse, but the surviving spouse has additional descendants, at least one of whom is not a descendant of the decedent. The surviving spouse would receive 50% of the assets, and the decedent's descendants would share the other 50%. If the person is not married at the time of death but survived by one or more descendants, then those individuals receive 100%. If the person is not married at the time of death and has no living descendants, the decedent's surviving parents would receive 100%. And if they are not then living, the decedent's brothers and sisters would receive 100%. If the person is not survived by any of the relatives described above, the estate passes 100% to more remote heirs that are determined in a certain succession order that is set forth in the statutes. Now, let's talk about the rights of the surviving family in the probate process. There is homestead that we will cover. There's an elective share for the surviving spouse, and what that means, the elective share is generally speaking 30% of all of the decedent's assets, including any assets that are non-probate assets. There is a family allowance and exempt property, and what we mean there is that a surviving spouse and the children, if there are any, may also have a right to a family allowance to provide them with funds before final distribution of the estate assets. And they may also have rights in exempt property that will be paid to them instead of to creditors in satisfaction of claims against the estate. There may also be pretermitted heirs, which occurs where a decedent is married or had children after the date of the decedent's last will, and where the decedent neglected to provide for the new spouse or children. That omitted family member may nevertheless be entitled to a share of the probate estate. Homestead is something that you've talked about. You may be familiar with the homestead exemption here in the state of Florida. Generally, the term homestead signifies the place where the owner and his or her family reside, the place where the home or the house is, and the adjoining land where the family dwells. The significance of homestead is twofold. Number one, in connection with real estate taxes, the homestead property owner may be eligible to receive an exemption of up to $50,000 on property taxes. And in the mortgage classes and the other financial planning classes that you will be participating in, you'll hear more about the homestead exemption. The homestead is also significant with respect to creditor protection. If you are sued and your creditor obtains a judgment against you, Florida law provides that the judgment holder cannot force you to sell your homestead in order to pay off the judgment. So in other words, once you're in your Habitat home, should you be involved in litigation with a creditor, they cannot force you to sell the home to satisfy a debt. The protection from judgment creditors will also carry over to certain heirs who inherit your homestead after you die, including your spouse, children, siblings, and nieces and nephews. Nonetheless, any judgments that are specific to the property, such as foreclosures, past due association fees, contractors' liens, etc., are not subject to the homestead exemption, and they may be assessed against the property. Now, the significance of homestead with respect to the estate planning that we've been talking about is as follows. Florida law restricts the authority to devise or distribute homestead in certain circumstances. At the time of a homestead owner's death, the following restrictions apply. If survived by a spouse or minor children, the decedent may only devise the homestead to the surviving spouse. If this person is not survived by a spouse or any minor children, then there are no restrictions. If the homestead is not devised or it's owned as tenants by the entirety, it descends the same way as other intestate property, except in cases in which the decedent is survived by a spouse and at least one descendant. In those cases, the surviving spouse takes a life estate with a vested remainder to lineal descendants. In probate, on the death of a decedent, a protected homestead generally passes outside the decedent's estate. Thus, a homestead devised to an heir ordinarily would be protected from forced sale to pay the expenses of administering the estate. However, homestead property can become part of the probate estate in unusual circumstances. The best exception to the general rule occurs when the will specifically orders that the property be sold and proceeds divided among the heirs. Let's talk about some estate planning considerations. We would urge you to ask yourself, number one, what would happen to my estate today given my current situation? How are my assets titled? Have I properly designated payable on death beneficiaries if I plan to circumvent the probate rules of the state of Florida? Ask yourself who you would want to have your assets after you're gone. Who would you want to be acting as your personal representative and your fiduciary? How would you like your debts to be handled? Consider a comprehensive estate plan by, as we mentioned before, seeking out legal counsel to have a will drafted. You may want to consider a revocable trust, durable power of attorney, a health care power of attorney, as well as a living will. We don't have time as part of this class to go over all of these, but I encourage you to ask questions about each of these, as they can be important estate planning tools. Now, in recapping the recommendations, again, review how your assets are titled. Sit down with your bank accounts, your checking accounts, look at whether or not they should be retitled as payable on death accounts. Consider how your future assets should be titled. Evaluate your current estate plan or seek out legal counsel for preparation of one. Execute a will and continue to assess your assets and estate plan. Are there any questions?